So there's an interesting 10th District case that ultimately went up to the Supreme Court in, it looks like 2015. And it involved an injured worker who suffered an injury in 1994. And that 1994 workers' comp claim was allowed for lumbar sprain and disc displacement. And this individual eventually ended up returning to work in 2009. And then in 2010, he suffered a new work injury. It could have been the same employer or a different employer, but he suffered a new work injury in 2010, which was allowed. And then in 2011, December of 2011, he settled that claim for that 2010 claim for $99,000. So he settled his 2010 claim for $99,000, and then he still had his 1994 claim open. And then I believe either a day or a week after he settled his 2010 claim, he requested temporary total disability through his unrelated 1994 claim. And so the Industrial Commission, and he was basing that upon the medical opinion and certification of his chiropractor. And the Industrial Commission did not find that the chiropractor's opinion was persuasive, and so they didn't grant temporary total disability. And then so this injured worker filed a mandamus, and when you file a mandamus, what you're trying to say is, the Industrial Commission abused their discretion, so that therefore whatever their decision should be overturned. So the 10th District found that there was no abuse of discretion on the part of the Industrial Commission, and then ultimately this injured worker filed his appeal to the Supreme Court. And the Supreme Court also found that there was no abuse of discretion, and they came to the conclusion, because apparently the injured worker was saying, hey, the Industrial Commission didn't consider the totality of the evidence, including the fact that this injured worker had treatment which was being undertaken, and then he had some newly allowed conditions. And the Supreme Court nevertheless found, even if there was new treatment and new conditions, that alone does not mean that you're, de facto entitled to temporary total disability. There has to be some persuasive medical evidence, and they didn't find that the chiro's opinion was persuasive. And the reality is, I also think that this is going on behind the scenes. It's not really written in the order or the decision of the Supreme Court. But the fact of the matter is, the guy settled his 2010 claim for $99,000, and then he's going to turn around and try to request temporary total. I think they had a little bit of a problem with that. So.